Okay, we ready to go?
Yes, Your Honor.
Okay, so Ms. Fryer, would you like to reserve some time?
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay, we're ready when you are.
Thank you. Good morning, Your Honors. May it please the court. I'm Elizabeth Fryer, and along with William Pennell, we have the honor of representing the appellant, Mr. James Duncan, before you today. Your Honors, in 1995, Mr. Duncan was convicted of 13 counts of child abuse related to his infant son. He was thereafter sentenced to 70 years in prison, 7-0. For over 25 years, Mr. Duncan has asserted his innocence. Well, in 2014, advances in forensic science caught up with the truth. Not only did Mr. Duncan not commit this crime, no crime was committed at all. His son's fractures, determined long ago to be the result of child abuse, were actually the result of a metabolic bone disease. Your Honors, we're here today on a consolidated appeal of two separate but interrelated claims. Primarily, Your Honors, we request this court order a new trial in this matter for the post-evidentiary hearing claim. That's what we're seeking, and that's what we assert justice requires. However, at a minimum, Your Honors, Mr. Duncan's entitled to a hearing on his successive 3850 claims of newly discovered evidence that were brought to light during the course of this litigation and summarily denied without a hearing after this court relinquished jurisdiction. Your Honor,
how is rickets a newly discovered sign as a cause of infant bone breaking of bones? How is that newly discovered evidence, particularly in this case where there was a differential diagnosis where they considered, I think it was Dr. Morris testified that was considered and rejected?
Thank you, Your Honor. I'll take that in two parts. I understand that to be two different questions. So what's at issue here is a very specific fracture. It's called a classical metaphyseal lesion, CML going forward to save a little time. But these are particular fractures that only occur in infants at the growth plate at the end of long bones. That's it. It's only when children are very, very small that these CMLs occur. So starting in 1986, the theory was that because infants can't roll over, can't fall out of trees, when what appears to be fractures occur on these long bones, it can only and specifically be a result of child abuse. What we have here is this new science that we're able to say, and definitively with this new 2019 article that we'll get to in a minute, that those fractures at the end of those long bones are actually just the lack of mineralization that occur in infants that are suffering from infantile rickets, also a transitory disease, something that passes.
Right. So what my problem with the way you're trying to frame this and contextualize this is that at a certain atomic level, you can make any kind of claim, newly discovered evidence, if you're willing to get to the granular point. Well, you're not saying that rickets per se is newly discovered evidence, but this one particular type of bone fracture, we're now saying, at least according to these gentlemen, is the result of rickets and not child abuse. And I guess I question how do you go about framing whether or not it's newly discovered when, depending upon what altitude you look at the issue, it is newly discovered or it isn't?
Sure, Your Honor.
Principles issue.
Sure, Your Honor. So in this particular case, and any case like this isn't just a matter of saying, oh, oops, it was rickets, something that we knew about for a long time, and it was dismissed by the state experts. That's not accurate. The state expert did a differential diagnosis with something called brittle bone syndrome. And based on the testimony related to that, that looks like a permanent condition, a condition that they would see over time. And the reason that they excluded it is because there were no longer fractures down the road. This isn't just merely saying, well, we now look at it and we see it's rickets. It rejects the CML theory entirely relied on at trial.
Ms. Fryer, let me ask you this question, because you keep talking about advanced medicine. I haven't seen the employment of any new medical techniques, research. What I see is a difference in opinion from review of radiographics and a blood test, because Ayub concedes he didn't review the skull or all of the ribs. Plus, the study itself says they didn't review Kleinman's films, but they cite research studies from 1943, 1948, 1953, 1986. But the conclusion seems to be they reviewed the same thing that Kleinman reviewed radiographically. And they do, take issue with the fact that he may or may not have had a pathologist. But the bottom line is what novel medical technique or brand new research was utilized in 2014?
So, Your Honors, let me be clear about what the underlying and cited studies in that particular 2014 article were. That was authority to move forward, like we all use, like we use in our briefs. But what happened here was there was a careful analysis of what had occurred under Kleinman. And then there was, like, the doctors that conducted this research were no slouches. They looked at this material under the lens of radiologists, board certified child pediatric geneticists who specialize in bone disorders, and made a determination. And then they took it one step further in the 2019 article. The 2014 article reviews and they were able to say, look, not absolutely, and certainly in Mr. Duncan's case, they made a determination based on their own evaluation. This certainly was no child abuse because of the factors that are required there. They did critical analysis of that. The 2019 article that occurred, and we asked for relinquishment of jurisdiction, took it one step further. They were actually able to do laboratory analysis on the infants as they that were connected to these CMLs and were in contested child abuse cases. They were able to test whether or not this theory was true by testing for levels of vitamin D and finding that their theory was actually correct. That's something that the court didn't bother to get in front of it. They summarily denied that, but 2014 establishes that the science relied upon on the underlying CML theory that was testified to at trial and at hearing by the experts has been discredited. That's what the law requires.
But what science, other than reading radiology or x-rays, what science? Because this article is replete with citations to research starting in 1919, and rickets has been around since 1690. And Dr. Foley, who was qualified to testify whether he had diagnosed rickets, did not. And the hospital did not diagnose rickets. Rickets has been around for centuries. So you have a very intriguing argument. You really do. This is an interesting article, but we've got to find that this is newly discovered and not just a difference in opinion between very well qualified experts.
Your Honor, we assert that it's certainly not merely a difference of opinion. The article itself, it does exactly what the law requires for newly discovered scientific evidence, and that is it rejects and discredits a theory relied on at trial by the prosecution, and that is what this is. There's no evidence that there was any testing done for rickets during the course of the trial. Infantile rickets is an issue that's been overlooked over time. This is just coming to light. I say to the court, though, if there's any issue with the 2014 article, what you'll find is the 2019 article takes it a step further in forensic science and really fills in those gaps. So it's not just merely a matter of
At the end of the day, it is doctors looking back at previous diagnoses and saying, no, I'm coming out different based upon a different view. That happens all the time, and I'm using that opening and asking to ask your thoughts. Given that that's what they're doing, what are we to do with the Florida Supreme Court's admonition in Schwab, which they categorize, they use this very broad language. I don't know if perhaps they meant to, but it's there and we have to contend with it. On page 325 of the opinion, as for Schwab's argument that he's entitled to a new trial due to two recent scientific articles regarding brain anatomy and sexual offense, this court has recognized, quote unquote, new opinions or quote unquote, new research studies has not recognized new opinions or new research studies as newly discovered evidence, which
Yeah.
seems to be the very silo that you all have. It's a new research study. It's a new opinion. It's a new research study, which the Florida Supreme Court has said in Schwab, we don't recognize that really as newly discovered evidence.
Your Honor, there's two issues there with the Schwab case. It was not, there was no discrediting of the underlying theory. Also, in the 2014 case, it wasn't just a matter of we've looked at these and we have a difference of opinion. They also reviewed correlates that occur within child abuse cases, and those correlates don't occur in these CML cases. The CML thing is a big deal. It only affects a very small area of bone and it's transitory. We've always thought that that was child abuse for decades. We're now learning that it's not. We expect to see bruising. We expect to see some kind of thoracic injury. Even the state's experts agreed to that. But what Schwab does is say you can't just take in old articles and act like they're new. This isn't a compilation of any studies that were previously done and that are repackaged. It just isn't that. It discredits the underlying science. This court,
well, actually in Schwab, it was a neuropsychologist who had examined and issued a report that the defendant in that case suffered from an organic brain impairment in the frontal lobe of the right brain. That arguably would have been newly discovered evidence because that was not put beforehand, or at least it wasn't litigated. That here's this new piece of evidence. I've made this diagnosis, and the court said no, that's just that was available beforehand. And we're not recognized. And the link was between it. I see the analogs here. That is the new fact, so to speak. What you're talking about is the conclusion that CMLs aren't necessarily indicative of child abuse. That's what you're saying is a newly discovered fact. And then now, based upon this article, we're saying that it's newly discovered evidence. I don't see how you're distinguishing Schwab under the circumstances.
no, and let me do a better job at that, Your Honor. In Schwab, the facts were as I read them and understood them, and I certainly can stand corrected if wrong. Where that Schwab himself had already raised brain damage previously in a previous post-conviction motion. He was given a hearing on that motion, and at the hearing, he provided no evidence of any brain damage at that particular hearing. So it wasn't just simply that there was it wasn't new because he had raised it previously before. He raised it later in greater detail, but because he didn't take the opportunity when he previously raised it to litigate it out, the court didn't give him a second bite at that apple.
Well, but see, here's the problem. The opinion actually, it addresses that, but then it goes on to say in pages 325 and 326 that the articles that he was trying to bring into play were not newly discovered, could not be considered newly discovered evidence. So you could make the analogy to, in your case, he could have brought out that rickets is a possible alternative diagnosis. He did not do so. And moreover, we have these new studies. It just seems to me to be kind of on point. I mean, I don't know how that gets around it, because he's trying to do the very thing that you're asking us to do in Schwab, which is take account of these two new studies that have come down that talks about whether, how the frontal lobe develops. And now let me bring in this evidence and let me get a new trial based upon this. I just don't see how that's different.
Respectfully, Your Honor, in the Schwab case in particular, they do a long line of reasoning, right? They rely on Diaz, they rely on Rutherford, and what they do when they cite those cases is they don't talk about what those cases were for kind of this proposition that we don't look at new evidence.
That's so what I wanted to get you to, Ms. Fryer.
No, thank you.
Was to say, I don't really think that Schwab meant what it said. And
Schwab does not mean what it says.
Right. I get it, but it's there. And we have to contend with that language.
Sure. Yeah.
Can I shift gears? Because I think we have talked about the newly discovered evidence pretty thoroughly here. What I'm concerned about is that they assume this is newly discovered evidence. The trial court found that it would not even if admitted, or if it could be admitted, which is an issue all by itself, it's not likely to produce an acquittal if it was in play because of all the factual scenarios here, which I'm concerned about. I mean, you have this Williams rule evidence, which is pretty damning. You have a prior child abuse situation. You have this analysis of that this is a vitamin D deficiency, yet this mother was on prenatal vitamins, and that there was no real evidence that there was any vitamin D deficiency in this child. So even if it came in, I felt pretty persuaded that it's not likely to produce an acquittal in this case. You want to address that briefly? And quite frankly, you're at 15 minutes, and I apologize for jumping in at the last minute.
It took me a while to get to Diaz and Rutherford. I'll take responsibility for that, Your Honor. So quickly, the Williams rule evidence was altered evidence. That was Mr. Duncan, the parents of the child, and Mr. Duncan's wife were all, it was unfounded. Dr. Sally Smith diagnosed it and years later changed it. And that's why the newly discovered evidence is so important. It was just a credibility issue on altered evidence. And then as to the second issue, there was evidence of rickets. I testified at the hearing, Dr. Ayub said that there was evidence of healing rickets at those bone ends that we were talking about. If you don't mind, Your Honor, I'd like to reserve the remainder.
Yes, no, absolutely. You can follow up even more when your time comes. Okay, Mr. Siegel.
Good morning.
Your turn, sir.
Thank you. May it please the court, Jeffrey Siegel on behalf of the state. This is basically, the Appellant's Journal article is nothing more than really a different opinion on old data, which we had just talked about. And it doesn't even meet any of the standards for granting a new trial on newly discovered evidence, because first, this is not newly discovered evidence. Evidence must have not been known by counsel. And as earlier as we said, counsel did know about this particular evidence by deposing the state's expert about brittle bone disease.
Mr. Siegel, let me divert you to my question, because we've spent some time on this, okay, whether it's newly discovered. I'm concerned about, assume that it comes in, is it likely to produce an acquittal in the next trial? Because you heard Ms. Fryer say that one of these doctors found evidence of rickets, but there was a lot of testimony also about the vitamin D deficiency and the lack thereof, at least arguably, in this particular child. You've heard, the discussion about whether it be admissible under Fry. You know the challenge to the Williams rule evidence, whether it should have come in. So that's what my concern is. If this were to come in, is it likely to produce an acquittal at the trial?
Absolutely not, Your Honor. And
well detailed.
The evidence provided that, according to the reports of the doctors who had actually seen the child, had seen the child's mother, there's no evidence that there was any sort of vitamin D deficiency. In fact, there's evidence that this child was properly nurtured as any loving mother would by taking any prenatal vitamins. And then, of course, looking at the x-rays before, after the particular incident happened, there is no evidence of brittle bone disease even before this incident actually happened as well.
Well, Ms. Fryer thinks there was.
There wasn't. The doctors testified that even in the child's regular doctor testified that there was no evidence of any sort of bone disease, never diagnosed any sort of bone disease. The child's mother was healthy, was delivered as a healthy baby, and 2 months old, had these particular fractures.
What weight or significance should we give to defense counsel that tried the case below, Mr. Mills, who had an expert retained who, according to Mr. Mills, expressly said there's no indications of brittle bone?
There is no indication of brittle bone disease because this child was particularly healthy. These particular CMLs are definitely indicative of child abuse. This child did not have any sort of bone disease, any sort of rickets, any other bone disease, any sort of other issues until this particular incident happened. So even before this child was healthy, and then after this child never showed any sort of problems with their bones.
So if we had a retrial, we would basically have experts coming down on differing sides in a jury question.
That's correct, Your Honor. And if this, of course, if this evidence was actually let in, because it wouldn't even meet the Fry standard, considering that this is evidence not accepted by the medical community. In fact, it was actually specifically rejected. There's the article, the letters to the editor indicating that Dr. Ayub's and Dr. Miller's testimony or journal article is actually particularly dangerous when diagnosing these types of diseases, and especially in regards to child abuse. And that's probably and of course, when you look at the child had exclusively injuries to the left side of the body with these CMLs, and if it was indicative of child abuse.
There was also testimony that that can happen, right? Either Ayub or Miller testified that, that this can happen all over all parts of the body, and it can happen where it's just centric to one area or one side.
Well, that's not what our experts say. It comes down to a difference of opinion.
Yeah.
And then, of course, you look at it wouldn't produce an acquittal at trial because you look at the jury question that, hey, is fractures on one side of the body indicative of bone disease? And our experts and really all the medical community says, hey, CMLs are indicative of child abuse. This particular child had injuries to one side of the body. If it was bone disease, it would have injuries to the entire body. And this is not the case.
Yeah, the credibility of all these experts was challenged, right? I mean, it was made clear that Ayub and Miller had only ever testified for the defense in these cases like 200 times, if I remember. Then Dr. Smith was challenged because of misdiagnoses in several cases that she had, she had performed in, and that was made clear. So basically, it sounds like that all of the experts' credibilities were compromised or challenged. I don't recall a specific challenge to Dr. Morris, who incidentally is no relation to me. I've never met him. So, but what are we to make of that? Does that matter at this level?
It doesn't matter at this level because we had the original doctors that testified, and Dr. Sally was really just a doctor that took over for Dr. Morris to corroborate in the original trial. So here, there's really no evidence that it's really just come down to a credibility determination. So, and Dr. Sally Smith is still practicing, and her record is, she's still testifying. So I think I could add to the record here. And if this court doesn't have any further questions, we ask that you affirm the post-conviction court's denial of appellant's claims.
Thank you. Ms. Fryer, you have 4 minutes.
Thank you, Your Honor. There's just a lot of ground to cover. It's a lot of years of litigation on this as well. So I want to make something really clear, and I know the court gets this, but just for my own edification, brittle bone syndrome is not CMLs. It just simply isn't. So to say that brittle bone syndrome was included or excluded or existed is immaterial to the claims that are before the court today. Your Honors, I would also say the Williams rule evidence in this particular case was the only evidence in this case that somehow tied Mr. Duncan to these issues. It's important to talk about what this case, the trial court did not have here. There were no injuries to this child. There wasn't a bump or a bruise or a mark on this baby's body with 13 fractures. Dr. Miller testified that would happen in less than 1% of cases. There were no witnesses. There was no confession. There was no psychological profile that would have put Mr. Duncan in this particular case.
Ms. Fryer, that's compelling information, but what has it got to do with this issue? This issue is about this newly discovered evidence, whether it should come in and whether it would likely produce an acquittal. So you're talking about things that happened at the trial, and yes, the evidence was thin in this case. There's no question about that. But nevertheless, the jury was persuaded by it. So at the point in time that we are, and the issue in this case, what you're saying doesn't seem to impact our decision.
Respectfully, Your Honor, knowing what Mr. Duncan was up against and the weight that new evidence would provide to the jury to get this question before the jury, if the issue, as the court has said, would be a credibility contest between the experts in this case, and that's the only evidence in this case, that's about, we would love to get this before a jury, because this isn't the kind of case where the evidence is overwhelming or this wouldn't have made an impact. This is a different case.
Well, but you raise an interesting point, but their credibility didn't get past Judge Andrews when he heard it post-conviction. He just did not believe them on, specific issues. So if he doesn't, we can't substitute our judgment for it. And as I say, I mean, there are 13 fractures. Sure, intuitively, if there are fractures and no edema or bruising, yeah, there's questions, but we weren't there. And Judge Andrews was there, and there was a full-blown evidentiary hearing, and each side had a full and fair opportunity to inquire and cross-examine. So if he doesn't believe him, we can't change that, can we?
You can, Your Honor.
Sorry, I don't mean to interrupt, but the other problem is that these cases always have very little evidence. The nature of these cases usually are an adult with a child, and there's just not much evidence. But go ahead and answer Judge Sleet's question, please.
Yeah, yes, Your Honor. And in fact, we're happy to be before you today because this court most certainly can overturn issues of findings of credibility of the trial court when they're not based on competent substantial evidence. This wasn't a matter where the trial court in this case made demeanor determinations that aren't reviewable based on the record. He pointed to specific facts that were misconstrued, misstated, and sometimes even changed. His determinations simply don't meet the level of competent substantial evidence. One of the issues was that these experts only testify for the defense, and so he just simply didn't find that believable. Your Honors, if he was a juror and shared that belief, he'd be stricken for cause. He has to listen to the evidence fairly. It matters. He had an issue with the asymmetrical presentation of the fractures. The trial court just could not get their head around the possibility that could occur. Well, the unrebutted evidence in this particular case by the medical experts who solely focus on bone health of infants is that this is an issue of mineralization, of filling in. It's not a perfectly proportioned system. These were mineralizations that should have occurred in utero. Because of deficiency, they're continuing to occur out of utero, and the evidence is that they most certainly appear asymmetrically. There was an issue that the judge made of finding that the immunization that occurred somehow stretch credulity in this case. What the court did was conjured up some.
So you know you're out of time, but go ahead and just finish. Okay.
But what I'd like to do is address any other issues that the court has, and if you don't, we're really thankful for this opportunity today, and we ask for a new trial in this matter.
Thank you both. Very well argued and well briefed.
Thank you. Happy New Year.
Thank you.
Happy New Year.
Our next case is Shalatz versus Punta Gorda HMA.